Legislature's back in session. I believe when we broke, Senator Uggan, you had the floor, and the sponsor was going to provide some information. Senator Adda.
Thank you, Mr. Speaker. In response to a question that was raised by one of the members, if a public hearings will have to be conducted when a rate petition is issued or submitted to the Public Utilities Commission. I have passed around actually all the sections of the PUC statute, which first of all identifies that the Guam Solid Waste Authority is a public utility, and that there's various sections. There's the Ratepayers Bill of Rights, which requires that a public utility no public utility shall submit a proposal for rate increase without first giving the people of Guam more than ample opportunity to exercise their fundamental rights as ratepayers. And under that is the right. One of the Bill of Rights is that the right to receive clear and adequate notice of any proposed rate increase. There's also Section 12117 of 12 GCA under public hearings, which clearly says that the Commission shall hold, Public Utility Commission, shall hold at least 3 public hearings on any change in proposed rates or charges. And then notices of hearings have to be given. And under that same section, the public utility shall notify its consumers of the proposed change in rates in the normal billing process, not less than 3 weeks before the date set for a public hearing. And then on section 12102.2, regarding proposed public utility rate increases, it reads, no public utility may submit a proposed rate increase to the Commission before complying with the mandates of this section. And it goes on and on. So there are certainly, the requirement for public hearings has been more than amply laid out in the Public Utility Commission legislation. Now, with respect to the Enabling Act of the Guam Solid Waste Authority, it does spell out in there the requirement that in order to do any kind of rate increase, they have to go to the Public Utilities Commission. But most importantly is that the Guam Solid Waste Authority is defined as a public utility according to Guam law, and it's spelled out very clearly all the public hearing requirements. Thank you.
Senator Uggan, is that satisfactory?
Thank you very much, Mr. Speaker, and I want to thank the good senator for providing that information. I know it references, based on the document that he provided, just like he explained, the Ratepayers Bill of Rights, which is providing the information, clear and adequate notice of the proposed rate adjustment, the right to be fully informed, and to fully evaluate any proposed rate increase, as well as the finances, the right to give input and participate in any proposed rate increase. And then it says public hearings, the Commission shall hold it. So I'm understanding that, in fact, that's the Public Utility Commission. It does, I'm not questioning, Mr. Speaker, whether sufficient information will be disseminated, let's say, for example, in a brochure by these respective utilities. My question was whether a public hearing is required to be facilitated by the respective government agency before it goes to the PUC. The PUC is the approving authority for any rate adjustment. This document under the PUC requires an additional public hearing, or it requires a public hearing on any proposed rate adjustment. And I knew that all along. I wanted to see if my question was in reference to the respective agency, if in fact Guam Solid Waste Authority is required in its statute, in its establishing statute, to be able to conduct a public hearing so that they can have that one-to-one direct conversation with our people. That would be in addition to disseminating the information to the respective ratepayers. So you provide the information. So I have it in a brochure. I write a letter to the Public Utilities Commission. Is very different from actually conducting a public hearing like we conduct on a regular basis and ensure the community is able to come in, question the rate adjustment, understand exactly what the requirements are, how the funds are going to be expended, what they're going to be utilized for, ask all the right questions so that the people of Guam can understand. That's all I was asking. I wasn't asking for the statute on the Public Utilities Commission because I'm very much aware that PUC has continued to meet its mandate of conducting public hearings once they receive a rate package from the respective utility agencies. Enough has been said, Mr. Speaker. So I wanted to share my perspective because I feel that that's a necessary part of the dialogue so that our people can understand exactly not only what is being proposed, how it's being proposed, and what the funds and the resources are going to be expended. Because at the end of the day, Mr. Speaker, the money will be coming out of the pocketbooks, the personal pocketbooks of our ratepayers and also many of the businesses out there. Thank you very much, Mr. Speaker.
Any other senator wish to be heard on the bill? On the main motion, Senator Talai.
Thank you, Mr. Speaker. I share the concern of an earlier speaker, one of my colleagues, and and I had asked this at the public hearing as well, when they do this rate study that's being mandated, do they expect an increase in the rates? And they wouldn't really answer that directly, but I think it's pretty clear from the earlier discussion that if they are going to take, well, they said for sure, if they are going to be responsible for the debt, it is going to result in a rate increase. And I coincidentally just attended the district court hearing on the landfill case when you were off island. And so it was made clear in that case, well, it was clear that the receiver was not applying for any rate increases or changes between now and the time that it supposedly ends the receivership. It was also clear that the liabilities, the operational costs were all going to be transferred over to the solid waste, and I guess that everybody understands that, but I guess it's my understanding that the current revenue is being used to pay operational costs, and the current revenue is not sufficient to pay the debt, although if I recall correctly, because I was at some very earlier, maybe years ago, hearings from regarding this case, that was the whole basis of the fees at the time, was to make sure that they were going to be able to cover, like you said, a revenue bond. So I just think it's unfortunate that the first thing that's going to happen when this gets transferred to the Guam agency out of the receivership is that they are going to look for a rate increase. But I would like to...
Point of information, Mr. Speaker. I don't think there was ever anything said about the first thing they're going to do is they're going to submit a petition for a rate increase.
That's correct.
The current rates were set by the receiver and approved by the court. PUC never opined on it. So the petition that's to be submitted is to then get it within the purview of the PUC, not necessarily to pursue a rate increase.
That's correct, Mr. Speaker. That's how this reads. I would like to make a motion to amend the bill on page 3, and where it requires, I think the new management of the Solid Waste Authority looks very promising, responsible, and I think you know, they are going to do a rate study, or if they haven't already begun one, but they made it very clear they were going to do their own rate study. That's one of the first things they wanted to do after they get a general manager. But I would like to remove the requirement that they must petition for adjustment of rates, which is in paragraph B on line 24. And here it says they must do this within 180 days from the termination of the receivership. So I would like to remove, first of all, I would like to, I'm on page 3, line 25, the sentence that reads, transmittal to the PUC shall be accomplished no later than 180 days from the date of termination of the...
Are you looking at the right?
Oh, no.
Substituted on the floor.
Okay, I guess I am looking at the wrong bill. Give me a second, Mr. Speaker. All right, sorry. Let's go to page 4. I think it reads the same. Page 4, line 4. So this subparagraph B is requiring that the authority shall prepare a petition for adjustment of rates and transmit to PUC, and that it shall do this within 180 days from termination of the receivership, which is December, according to the court. That's their target date. I would like to remove this sentence, the transmittal to PUC shall be accomplished no later than 180 days, and leave that up to when or if they think it's necessary. And I would also like to change the word shall in the first sentence to read may. So B will be, and this would make this agency similar to the other agencies where they're not required, but you know, they use their discretion. B says the authority, so I would like it to read, the authority may prepare a petition for adjustment of rates and transmit the petition to PUC. And delete the next sentence so that they're not required to do this within 180 days. And that way, if they do a rate study and they find that it's not necessary to increase rates or change their rates, that they would just maintain the current rates. So I guess I would...
On the motion by Vice Speaker Terlahi to strike the second sentence in B on page 4. Any senator wish to be heard on the amendment? Senator Adams.
First of all, it's presumptuous to think that when they submit the petition for adjustment of the rates, that the rates are only going to go one way. It's going to go up. It could also go down. That's why we are trying to get out of this receivership, because we are paying, for example, $1 million for the management of this operation when we could be paying much, much less than that. And so if the PUC takes a look at what it's going to cost and the costs do not justify the rates that they are, then they could adjust it downwards. But the primary reason why they're submitting a petition is to simply get those rates ratified under the Public Utilities Commission. Our law says that the PUC is the one that will set rates for the utilities. These rates were not set by the utilities. It was set by the receiver, approved by the court. We had nothing to say about it.
Vice Speaker.
Thank you, Mr. Speaker. That's correct. The court approved these rates, and we, by this bill, are again approving these rates. we're setting these rates. Otherwise, I mean, that's exactly what Part A on page 3 does. It approves these rates that are in place. And there's nothing to prevent the authority from going in. I am sure that if they find in their study that they're going to be able to decrease rates, that we're not going to be able to stop them from getting this to the PUC. So I have a lot of faith in that. I just don't want them to be required. There's no reason to require them to submit rates if they're not going to request a change to the PUC. I think that's just going to be expensive. It's going to require the PUC to study those rates and concur whether they are correct or not, but we are already doing that, and the receiver has done that for years. I mean, they still have the authority to transmit a rate study, but it just doesn't require that they have to do it if they don't want to change the rates at that time, or that they don't have to do it within 180 days. Yes, but they may prepare a petition. Of course, they're authorized by statute. When we created this agency, we set it all up that they would act like those other autonomous agencies that set rates under the PUC. So when they are ready and when it is necessary, then they go to PUC and set rates, because it's a very costly process also. The study they do is pretty much, you know, there's another study that PUC does. And so those costs get transferred to the customers. So I would like to avoid that if it's not necessary.
And for all the members, subsection C provides a very detailed process by which rates are going to be proposed, that the authority shall publish 60 days, and everything is in this statute. Is in this proposed statute. It's here. On the motion, any other senator wish to be heard on the Vice Speaker's motion to strike the 180-day requirement that they finish the study? There's been an objection. All those in favor of the Vice Speaker's motion to strike the second sentence, please raise your hand. Motion fails.
Thank you, Mr. Speaker. I just also wanted to comment on the bill that the transfer of the employees and other transfers that are proposed in the bill were also discussed by the court, but I noted also at that hearing that the court its target date to end the receivership is December, but before December, they are in the process of locking up, the receivers in the process of locking up contracts that will last, and the ones that were proposed to last for 28 years. A contract for a trustee to pay an engineer and the contractors who are going to be closing the ORDOT landfill. And I was surprised when I heard that, because I thought that this was the duties that would be transferred over to GSWA, and that was their argument at the hearing. I don't think there's been a decision on that certain debate, that they want it to be the ones that, you know, handle the contractors for the closing of ORDOT instead of the
Point of
the
information,
trustee-
Mr. Speaker.
The trustee that they were also applying for a trustee, a second trustee in this case. Yes.
So the issue about the court appointing a trustee to oversee the closure of ORDOT is still under consideration. It has not yet been ordered. And yes, the government has made its argument that they don't need a trustee. Just let GSWA do that. But that's still under consideration, and it hasn't been finalized yet.
I believe that's exactly what I said, Mr. Speaker, that that's what the arguments were made at court and that we haven't heard yet from the court the decision. So thank you. But I just wanted to note that because there are obligations that it looks like the money that, that they're going to be liable for, but they will not have control over. I mean, potentially, if it just depends how that court case goes, but I thought that was very surprising. So this authority is going to have a big challenge because it's being responsible for things, yet, yeah, its control is potentially limited for 28 years. Just wanted to put that on the record, Mr. Speaker. Thank you.
Thank you. Any other, Senator Nicholas?
Thank you, Mr. Speaker. Mr. Speaker, I do have a proposed amendment, but the language, I don't have the exact wording for the particular part of it, but I was wondering if I could proffer it and perhaps get your assistance or the assistance of legal counsel. On page 5, lines 12 and 13, after the word liabilities, I wanted to add the words other than the, and then put the technical description of the bond that is backed by Section 30 and currently funded by our Section 30. That's the amendment I'd like to proffer. That way, when all of the debts get assumed by this new authority, we're not automatically dumping that bond into their obligations and then causing that to automatically impact the rates. If we want them to absorb that, I think at a future date, we can mandate that they float a revenue bond and fully absorb it with a separate issue, a separate bond issue, and go through the whole process of doing that. But at this juncture, because it's technically a limited obligation bond, I just find the likelihood of that just getting stuck into the authority without it being fully vetted to be too much of an ask for me at this point for this bill. So I would prefer that in this section we have them assume all of the liabilities, agreements, and privileges of the authority or attributable to the authority with the exception of that one particular bond. So that's the amendment that I would like to proffer after the word liabilities, add the words other than the, and then the legal description of the bond that is currently backed by Section 30 and funded from the general fund.
On that amendment, Senator Ada.
Thank you, Mr. Speaker. Mr. Speaker, I fully understand the concern of the retiring speaker, but I would have to object to that. And the reason why I object to it is, first of all, the whole focus of this bill is to effect the transition of this solid waste management operation from the receiver to Guam Solid Waste Authority. Now, it's very possible that, and the concern that I have with the amendment that is being proffered is that then the executive branch may interpret that with that language, GSWA will never assume the Section 30 or the debt service, which right now is being paid for out of Section 30 funds. And I want to emphasize that again, I think that the appropriate place to that this should be addressed is when it gets to PUC, and we will know about it way before any decision is made. And if they're leaning in that direction, that they're gonna assume that responsibility and see rates increase sky high, I'm afraid that the unintended consequences of that is going to be, that would be very irresponsible, I think, on the part of Guam Solid Waste Authority. So, but I think that this is not the juncture where we need to address this. And I guess I'm just trying not to make any changes that would risk the passage of Bill 111, so that we can, let's get out of that receivership first, and then let's sort out these things further down the road, and there will be opportunities to do that. Thank you. So I object.
Any other senator wish to be heard? Any other senator wish to be heard? If not, do you wish to close?
I do, Mr. Speaker. The bond and its impact, I think, needs to be very carefully put into context. We were ordered by the federal government to close Ordut and build Luzon. The bond was floated in order to comply with that court order. Even if we had 0 ratepayers, we would have still needed to build Luzon. It was an order. That's why we floated the bond before even any revenue was being generated by the authority, so that we can construct the landfill and get it done. Now we have a rate structure in place, but only a finite number of ratepayers. There's a very distinct difference between having to float a bond to comply with a court order to close the dump and open a new one, and floating a bond to provide services specifically to ratepayers. Yes, that bond built the new landfill, but that bond was an order by the federal government for us to be able to meet the mandates. That's why the obligation is shared by all of the taxpayers. If there were 0 ratepayers, we would still need to pay for that bond in order to comply. Now what we're going to be doing is, by having only the ratepayers absorb the entire liability, is we're sticking the fault of this government to properly manage Ordut onto the backs of all of those ratepayers, who are now going to have to pay for that bond that this government was ordered to float in order to comply with the federal government's requirements due to the Ordut mess. The rates that are set for the ratepayers right now are going to fund the operations of Luzon. Fine, I pay my trash bill. It's because I'm receiving that service. If the bond gets fully pushed into the rates, then it's only those who are using the service that are paying for the fault of this government to properly manage Ordut over all of those years. And those are two very separate issues. I can understand as a ratepayer if my trash service is going to improve because we're going to float a bond to, have gold-plated trash cans. Okay, fine, put us through a public hearing. It's a service that I'm going to be paying for. But this particular bond is not specifically for the ratepayer to get the service. It was to comply with the federal government's orders. If there are no ratepayers, we would still have to float that bond. So I'm of the opinion that because that's a liability of the government that we created for ourselves over all the mismanagement on Ordut, that the government should continue to absorb that obligation. Otherwise, we're only making a limited number of ratepayers be on the hook for all that debt service that was a government problem. It wasn't a customer problem. The ratepayers are not the ones that screwed up Ordut. And not everybody is a ratepayer for our trash services. That's part of the problem. Another issue that concerns me about this is that as these rates were set to be able to provide the service, only a limited number of people are paying that rate for that service. That rate was set by the courts. And now that rate is going to be adjusted upwards, or however, maybe downwards, I don't know. That rate is going to end up being adjusted, but now we're going to be forcing this bond to be a part of that. It concerns me because as the courts determined how to establish those rates, if this bond isn't already factored into that, which we've heard already it is not, then we're basically going to force it onto the ratepayers by not passing this amendment. Now, if we pass this amendment, here's what happens. Status quo. The bond still exists. It's being paid out of the tax revenues. If we want to turn around and have the ratepayers absorb that bond, then they can go through the normal process of floating their own revenue bond, increasing the rates to cover that revenue bond, and then using that revenue bond to pay off the Section 30 bond. Then the ratepayers will be fully informed. They'll know exactly how much that's going to cost. Eyes wide open. But right now, we're looking at sticking it to just those limited ratepayers, the entire cost obligations of shutting down ORDIT. And it's grossly unfair. It's grossly unfair to put that entire burden on the backs of the ratepayers who weren't the ones who created the liability. On a related note, part of the reason why we don't have everybody paying the rates is because not everybody can afford it. And as the rates increase with the pushing of this liability into the ratepayer charges, how much more is that going to exacerbate the problem? And because it still technically would be a Section 30 bond, a limited obligation bond of this government, if the rates go up, and if the number of ratepayers drop because the costs are becoming too prohibitive, we're still going to have to pay for this. So we're going to have a limited number of ratepayers paying a higher amount, ratepayers falling off, which results in more illegal dumping, and the government's still on the hook. So I highly recommend to the body that we adopt this amendment. This amendment will not derail the transition. It would just make sure that that particular liability stays where it is right now. If we want to move it in the future, we can move it in the future. But I'm very uncomfortable sticking the entire liability of the ORDOT debacle onto the backs of the responsible ratepayers who are still a part of the current system. Especially when we don't quite know what the impact is going to be. Granted, it's written in here there's going to have to be a whole process, but what's done is done. Once we pass this, they absorb the liability. So I humbly ask my colleagues to seriously consider this amendment. It won't derail the transition. It will keep the liability where it is. And by the way, if we don't pass this amendment and that liability transitions over, not only will the rates be impacted on the ratepayer side for this debt service, it will free up debt service on the government side. And then we're going to be jumping into the free-for-all over where that money is going to be getting spent. And believe me, the administration has had their own idea of where that should go. And we do need to free up resources on the government side, but not by putting the entire burden on the backs of the few who are doing their civic duty by paying their trash fees and disposing of things properly at the risk of exacerbating the illegal dumping problem. Thank you, Mr. Speaker.
Thank you. There's been an objection to the amendment. All those in favor of this Nicholas amendment, please indicate by raising your... Oh. The amendment is every obligation of this will be transferred except the indenture. Whatever the name of it is, and they'll write out the whole legal name for it. So that's the effect, is that all their current obligations except for the loan. You get the house, but not the mortgage. All right? Does everybody understand?
May I request a brief recess, Mr. Speaker, just to get some detail?
We'll recess for a second. You're recognized, Senator
Thank you, Mr. Speaker. I'd like to beg the indulgence of the body and withdraw my previous amendment and go ahead and focus on the amendment that I've circulated, if I may withdraw the initial.
Any objection? And the new amendment?
Thank you, Mr. Speaker. I've circulated an amendment that I would like for the body to consider. The language is that we're going to replace after the word authority on page 5, line 14, other than the 2016 limited obligation section 30 bond. But if you read the writing just underneath it, the motion will also need to include, and further to allow legal counsel to make any technical amendments to the title of said bond in the event that it is not the full and accurate title. And the reason why we're including that statement there is because sometimes, depending on what's suitable for bond counsel, we may want to include the QSIP number of the bond, and I'm not quite sure if that's going to be necessary in order for this to be fully effective. I want to grant legal counsel broad authority to be able to write this out as technically as possible as necessary. So I'd like to make a motion to amend the language as circulated, Mr. Speaker.
Thank you. On Senator Vice Speaker.
Thank you, Mr. Speaker. I support this amendment because I believe it is a decision that the legislature has to make. We know for a fact that if they include this debt service in their rates, the rates are going to go up. And I think we should decide now whether we are agreeing that the current solid waste rates are going to go up before we allow them to spend all this money on their rate study, submitting it to the PUC, and the PUC does their study. And the reason I say that we need to decide that, Mr. Speaker, is because one of the biggest issues that faces our community right now is solid waste. Despite the receivership over all these years, we still have an issue of, as the previous speaker said, those people who are not subscribing to this service, to the illegal dumping that's being done in the villages, and the mayors have brought this to our attention over and over. They cannot keep up with it. Nobody can. Every environmental agency tells us this is an issue we need to deal with, and I'm not sure if that the legislature, that's how we intend to deal with it, by raising rates on the ratepayers, or if we can deal with it another way. I mean, I already think the $30 a month is significant, and so we need to look at another way. I'm hoping that this authority, they're going to do it. But what I would like, Mr. Speaker, is that when they do their study, which they say they're going to do, and the study's not being mandated in here, but I mean, it's obvious because they have to submit something to PUC within 180 days, and they've promised that they are going to do a rate assessment right away. But I would like them to assess the difference in the rates with or without the debt. And if I recall correctly, at the hearing they said they might do that, but I just would like that to be very clear that by putting in this language, we don't prevent them from including that in their study if that's what they are already doing. I'm not sure if this study has begun or it hasn't, but so that then, Mr. Speaker, the legislature can make a very conscious decision. And I think it should be the legislature that makes a decision when we see the assessment being done by the agency, whether they're going to go in for a rate increase, because whether it's justifiable because of the cost of operations or the cost of the debt, the effect of it, I think we can already predict that increasing it beyond $30 for most residences is going to be, it's going to make the system lose customers, and I don't think that the legislature wants to do that at this point, and I think that that's something we have to avoid. So as we are the policy makers, and I feel like that's the policy that if we can direct them in advance, that we should do that.
All right, thank you. Senator Ogden, then Senator Torres.
Thank you very much, Mr. Speaker. Mr. Speaker, I certainly stand here to raise a concern, Mr. Speaker, because back, I believe it was 2008 or 2009, where the whole case with regards to the construction of a brand new landfill or a brand new dump was presented before the courts. And the courts more or less coerced the hands of this legislature or the government of Guam to be able to identify funding. And that's where this particular bond was floated in the amount of approximately $210 million for the construction of the Ladson landfill and the closure of the ordered dump. My concern, Mr. Speaker, with regards to inserting this provision and providing a restriction other than the 2016 limited obligations section 30 bond, which was tied directly towards what I just mentioned, the Ladson landfill as well as the closure of the ordered dump, whether this could conceivably result in the judge questioning whether, in fact, she wants to meet her imposed December timeline in returning the Guam Solid Waste Authority back to the government of Guam. And I just wanted to share that particular concern because certainly it would be an issue. I support the contention and the intent of this particular legislation to be able to get this Guam Solid Waste Authority and the responsibilities back to the government of Guam so that, in fact, we can carry out its operations. But inserting such a provision could cause concern if the judge were to look at it and say, okay, unfortunately, the government of Guam may now be imposing some additional restrictions, but I understand the intent, and I believe the good sponsor made it very, very clear that the people of Guam and the ratepayers need to be part of that conversation and need to understand that if there's going to be any rate adjustments, what will those rate adjustments be, and can our ratepayers actually afford it? Because, Mr. Speaker, it's certainly it's not worth what we've seen over the course of the last few years, where some people have used roadways along Simon Sanchez High School to dump their own trash. One individual that I met a short while ago said, why don't you just give it free to the people of Guam so that they can stop dumping? Well, we tried that at one point in time before it transitioned into a fully compensated program for the services, and similar situations occurred. So, Mr. Speaker, that's the only concern I wanted to share with the members of this body, whether in fact this could cause a pause on the part of the Chief Judge in rendering her decision to allow the process to continue to proceed and return this particular trash collection and disposition operation back to the people of Guam, albeit the government of Guam. Thank you very much, Mr. Speaker.
Thank you, Senator. Senator Torres, you're recognized. Any other senator wish to be heard on the amendment? Any other senator wish to be heard on the amendment? Do you wish to close? Is there an objection? Hearing no objection. On the main motion, any senator wish to be heard on the main motion? Senator Addott, you're welcome to close.
Thank you, Mr. Speaker. And I thank my colleagues for the input that they have given. And I certainly hope that we will act on this favorably, because this Bill 111, I believe, is the linchpin in getting the court to effectuate the turnover of the receivership to the government of Guam, to the Guam Solid Waste Authority. This particular vehicle, Bill 111, was formulated in collaboration with the Attorney General's Office, the Guam Solid Waste Authority Board of Directors and their council, and of course we've had input during the public hearings. And the court is fully aware of Bill 111 and certainly has not mentioned anything to the negative. So I ask my colleagues to act favorably on the bill so that we can get this receivership terminated. Thank you.
Thank you. On the motion to send the Bill 111 to the voting file, Any objection? Senator Castro, you're recognized on Bill 123.
Thank you, Mr. Speaker. Upon introducing the Attendant Bill 123-34, there were several concerns that were raised. And if it's appropriate, I'd like to go ahead and address them individually. The first would be a request from members of the body for some documentation that would affirm the administration's support of the bill. And so I have that, if I can pass it out. Okay.
Can staff please assist in the distribution?
And if I could also request, Mr. Speaker, to have the letter by DRT Director John Camacho, which is being passed around right now, entered into the record. In summary, the letter basically underscores both the Governor and the Department of Revenue and Taxation's support of Bill 123-34. It also affirms my earlier statement that the provisions of the Real ID Act apply to all applicants for a Guam driver's license. The second issue, Mr. Speaker, was some concern relative to the Real ID Act, and I had the opportunity to discuss those concerns with one or more members of the body, and if anyone's amenable to an amendment to the bill, we can introduce that if there are any additional concerns, if I wasn't able to satisfactorily answer the Real ID questions that were posed yesterday. And then the last concern, Mr. Speaker, there was some concern that it was posed that it's possible or suspected or theorized, because I haven't seen any documentation that would support the assertion that residents of Guam would flock en masse to the CNMI in order to circumvent the graduated driver's license program as implemented at the Department of Revenue and Taxation. With that said, I was in communication with Representative Ivan Blanco of the CNMI Legislature this morning, who introduced mirror legislation Bill 20 in the House, and he will be introducing an amendment that would require, should one be absent in the current statute, a residency requirement for first-time driver's license applicants in the CNMI. Subsequent that, I was privileged enough to meet this morning at 5:30 and again at lunch the Chief of Staff to the Governor of the CNMI, and he too has expressed the Governor's support to ensure that if there is a residency requirement either in statute or to be introduced and passed by the CNMI Legislature, that they would do everything within their administrative authority to ensure the integrity of the program. Thank you, Mr. Speaker.
Thank you very much, Senator Castro. Senator Atta, you're recognized. After Senator Atta, who wishes to be recognized? Senator Atta.
Thank you, Mr. Speaker, and I appreciate the sponsors' efforts to get this letter on the record. I just have one question. So we have affirmed here that the, I guess, with Bill 123, if a resident of the CNMI was to come over here and wanted to change his CNMI driver's license to a Guam driver's license, he would have to comply with the Real ID Act. Now, here on Guam, according to that last paragraph there, CNMI driver's license holders must apply for an operator's license, pay applicable fees, and comply with the Real ID Act. So if at the CNMI end he applies for a driver's license, I guess do they have to comply with the Real ID Act? Go and get a verification from their mayor that they live in that particular village, et cetera, et cetera?
No, Senator Atta, not in terms of acquiring a CNMI driver's license. But just, if I could, just can I extend the remarks there? For the record, the Real ID Act is optional, and it's actually a standard established by the federal government for the purpose of interstate travel. The answer to your question is if they come to Guam with the desire to exchange their CNMI license, assuming that they meet the other requirements like having held it for no less than a year and it's valid, that yes, the short answer is yes, they absolutely have to abide by the Guam implementation of the Real ID Act. So yes, they would have to go to a mayor to establish residency requirement here on Guam.
So then that assumes that the CNMI, the holder of the CNMI driver's license is going to be establishing residency here on Guam?
Yes, sir. And that is the intent.
Okay, thank you.
Any other senator wish to be heard? Senator Torres?
Thank you, Mr. Speaker. You know what caught my attention about this bill is that it's intended to give anybody who intends to stay in Guam past 30 days at a time may use this program this reciprocity program to get a Guam driver's license. But in looking at the requirements for Guam Real ID, it requires a lot more than simply deciding that if you're going to be here for over 30 days at a time, that you can switch over your license from the CNMI to Guam. Because in order to get a Guam ID, you have to present your Social Security card under the Real ID Act. Your Social Security card, a mayor's certification of proof of residency, proof of a valid presence in the U.S., either a certified U.S. birth certificate or U.S. passport or valid foreign passport with U.S. visa, an I-94 card and permanent resident, or certification of naturalization. And so, you know, when I first read this proposed bill, I thought that it was a little lenient in allowing people who are intending to be here past 30 days to simply go in and get a license. And it almost gave it the feel of a nice souvenir for having been on Guam for over 30 years. And so the question about the Real ID I thought was a very legitimate question, because most of us use a driver's license as an official form of identification that not only certifies your identity and that your information about who you purport to be is true and lawful, but it also establishes that you are in fact a resident of Guam. And you know, the test of having to go to the mayor's office and get a certification that you're a resident of the village, you know, is the indication that you are a resident. So this transient nature of this reciprocity, it was a little concerning. I understand, you know, the idea of having a relationship with our islanders and being able to do that, but I think that what concerns me about this bill really is anyone who intends to stay here past 30 days at a time may be. And then the reasons in the legislative intent almost made this arrangement seem somewhat frivolous, because it benefits students, persons conducting business on Guam, members of the armed service residing in the CNMI, those traveling for medical purposes, which is not permanent, and those choosing to recreate, which is not very permanent, shop, or whose stay may extend past 30 days. So if in fact this is about allowing someone with a CNMI license, because we know what it's like when you relocate and you plan to be there more than, say if I were a student and I was going to be in Guam for you know, a year or 2 years, that would be understandable. But the legislative intent really makes this program seem like it's almost like having a nice souvenir of a long stay in Guam, just by the way that it's written, that you can one of the reasons for this reciprocity program is for those that are coming to Guam to shop or to recreate or to have some medical treatment. So if in fact it's tied into the Real ID program where it has to require a proof of residency, then I would support the idea. But, you know, to have it be where you could very easily get a Guam license and then go back to the CNMI and you know, claim that you lost your license and get another one there, it doesn't legitimize what a lawful government issued ID is intended to be. It's a verification of your identity, your citizenship, and your residency. And I don't think that we should be so loose about those requirements. I mean, if you're going to be an ID holder of one jurisdiction, then that should be your true documentation. And this past 30 days at a time seems a little, particularly to recreate or shop, just seems a little bit loose and it doesn't lend to I think the government official status and of the document. And that's what concerns me, is it just doesn't seem as official when it has this kind of intention written into it. So perhaps that concern, though, is negated by the fact that there will be a proof of residency which the mayor will have to attest to. And if the author wants to allay that concern, I would welcome that as well. Thank you.
Thank you, Mr. Speaker. First, I humbly appreciate the extended support because we're meeting one or more of the provisions of the Real ID Act. But to address the extensive comments about whether or not one wants to travel for 31 days or 31 years, if the privilege is extended to residents of New York City, extended to residents of Vermont, Washington, D.C., the People's Republic of China, the European Union, whether it's 31 days or 31 years, angin edzo pun faisano, sofana tesinya tanai itseluta, ginenotin Marianas edzo no idzokta ID. If they want to come for 32 days, I would much rather give my brother before I give any person outside the Mariana Archipelago. Sa hafa that masnahit tanai esti mina lago niya zani man tauto san lago oportunidad zan derecho kinu para iman tauto Marianas. Mutsu mas iman sumoru na para na maput ilay zan irregulasyon pada siya. Hafa Mohon. It is more than just this token driver's license that I'm attempting to establish as a matter of public record that I hope and I entreat will be passed in the Northern Marianas Legislature. As trivial as an operator's license is, this is so significant to the symbolism that's needed to bring our two island communities together. And yes, I thank my brothers and sisters in the Northern Marianas for gladly accepting my Guam ID, whether I'm there for a day or whether I was there for 2 years like I was 10 years ago or 8 years ago. And yes, whether you're coming here to shop or to care for your aged mother or even best, to achieve a higher education in a 4-year degree that's not offered at the Northern Marianas College. It's a small price to pay, Mr. Speaker, to extend the privilege, provided you meet the provisions of the Real ID Act and any other local requirements of Guam law. Any day of the week, any month of the year, any year as long as I'm alive, I will continue to fight for those extended privileges, driver's license, free trade, or God help us, one day, one great Chamorro nation. Thank you, Mr. Speaker.
Thank you, Senator. Senator Torres.
Hi day, Mr. Speaker. Tutungko ko para malago na bekoti pat be tsalik. This is not a matter of a case for the reunification with the CNMI, which I wholeheartedly support. What I'm bringing out is the fact that there are considerations and there's a certain level of officialness with regard to IDs. And I bring it up because we do see on Guam a problem that has been brought up with identification, with people, you know, working with a system where you can establish you can get different social security numbers, you can have different IDs using different addresses. And this is a case that has been brought up with the court system. And so all I'm doing is I'm trying to bring up the importance of having to establish that if you're going to issue an ID, that it is bona fide and that it in fact reflects a person who is a resident of Guam. I'm not taking jabs at our people and our brothers from the CNMI by any sort. And, you know, please do not make this a political issue. All I'm doing is I'm just bringing up the different requirements of the Real ID program and bringing up the idea that if we're going to have a system, that we have to make sure that it's consistent and that we don't allow for an abuse of a system that is really designed to ensure that it is in fact a real ID, that the person who holds the ID has met all the tests of their identity, their social security number, their U.S. citizenship, that they're in fact a legitimate resident of the area, and that their residency is confirmed by the mayor. That's all this is. Don't politicize it, and don't make it a me against my brothers of the CNMI, because it is not. It is, the points I bring up are valid insofar as wanting to make sure that if it's about getting an ID, that it's not, it is that, and it's not just as easy as deciding that you're going to get an ID for the sake of having a Guam ID. It has to be a true and correct ID that speaks to the residency, the true residency of the person, and their citizenship and the like. That's all. So I do resent the political outcry. This is not about a case for reunification. It is not that I'm questioning that I don't want a reciprocity program. I've taken advantage of a reciprocity program in the past when I was a student in the States, and I relocated for a period of time, and I gave up my Guam driver's license. I totally get that, and it's a good program. All I'm saying that is the way that it's written right now, it makes it so accommodating, and I don't know that it really, it makes it very accommodating, but the way that it's written, it seems like it's not as true to the Real ID program, although that's been dispensed. So, my point, no political CNMI on tungo na tomorrow to lokwi za magado sinaw fina tomorrow angin eno malago eno malago ito na parbe fina tomorrow bu sina hadzu fina tomorrow gwini lo ti edzo ilaleko gwinhi u quintuti si hamzu na guahanu cuestiones para este real programs any ID. Edzo ha ti put hamzu ni tau Mariana za hami tau Guam ti edzo ilaleko. So put favor and gin ti atung office tino hafai raison ho na para be kahulu za be quintusi I tselu gwini zani toro I tau I senador siha. Ti sinyaw Sagani hafa no resonya lo guahu utungo no hafa na gaigi zuweni za utungo hafa leleko za angin claro ju pues por favor vai sinzu hafa leleko za be sagani hafa angin tun comprendi hafa leleko sina una maulik. Zeus Masi, Mr. Speaker, Manad Zenzo.
Thank you, Senator. Senator Castro.
Mr. Speaker, with that said, could I also proffer an amendment to the bill? It's been passed around. And I thank a couple of my colleagues here, namely Senator Mike St. Nicholas, for raising the issue yesterday. And in your hands, members of the legislature, should be proposed language that makes it abundantly clear. And it's double underlined here that persons applying for the Guam driver's license as part of this reciprocity agreement shall also do so in conformity with the provisions of the Real ID Act as implemented on Guam. And what this does, in my opinion, Mr. Speaker, is it doesn't leave it to the discretion of any administration to determine by rule or regulation and not as explicitly stated in the statute. So that's my proposed amendment to the bill, Mr. Speaker.
Does everybody have a copy of the Castro amendment? Anyone wish to speak to the Senator Ada?
Thank you, Mr. Speaker. Well, first of all, I kind of take exception to the statement that we're seem to be reticent, I guess, about acting favorably on this bill for something as trivial as a driver's license. I don't consider a driver's license as being trivial. At least it's one measure that the drivers that we have out there are qualified to be out there. It doesn't guarantee that they'll operate safely, but at least it's one measure. So it is not a trivial thing. Now, I do have some concerns even with the amendment here, and that is, as it reads right now, if an individual from off-island comes in and has held a driver's license for no less than 1 year, he may then exchange his license for a Guam driver's license. Now, I recall, and we can take a recess and ask legal counsel to look through it, but if I recall, in Guam law, this sort of exchange is allowed with the states that we have reciprocity with right now, but the requirement is that you have held that driver's license for at least 5 years. So why are we lowering that standard? The second thing is that my understanding is that in the CNMI, you basically take one test, and that driver's license, you can basically operate an automobile, you can operate a commercial vehicle. It's basically one license fits all. In contrast, here on Guam, you take a license to operate a motorcycle, a different test. You take a different test to operate a commercial vehicle, a different test to do a commercial vehicle, a truck. So it's not one, on Guam, it's not one license fits all. And I guess we need to either verify that, it's been a while since I read the Guam law, but what sticks in my mind is the 5-year requirement in order to be able to exchange it without having to take the driver's, the written exam and the road test. And also the fact that there are different test requirements for different licenses. And finally, the language as written gives the impression that if you've held that driver's license, you can just come in and change it. But if you read further into our driver's license law, there's provisions in there that says the director of the department has every authority and discretion to be able to say no. I guess you'll have to come up with valid reasons to deny that. Whereas the way it's written right here, it kind of almost suggests that you come in, present your license, we'll exchange it, and we part ways. But that's certainly not the case. I was quite surprised to see how much authority the director has in disposing of things like exchanging the driver's licenses. So I do have concerns. Thank you very much.
Thank you, Senator.
I'd just like to address the concerns. First of all, thank you, Senator Ada. Those are legitimate and they're outlined specifically in the statute. And you are correct in that the 5-year requirement is actually only one of several provisions that may be applied. And that's exactly the concern. They're not uniformly applied in all instances. With prior comments about whether I was directing my specific address to any one person or the other, Senator Tom Castro Ada, I do sincerely apologize. Senator Torres, if you saw yourselves as being the recipient of my message, That certainly was not the case. There are others who have concerns. And so if you took that personally, I know for the record I did not call you out. But I will like to respond to Senator Torres. Ma'am, with all due respect, no matter what message you should deliver on the floor, please know that I will never go on record as either having wanting to cry or ever laugh at your attempt to unify your family or do something well for your community. I don't take exception to your comment. I just do apologize that I couldn't leave a favorable enough of an impression to move you to understand my plight and my heart condition. I was in no way addressing you directly, and that's it, Mr. Speaker. I didn't want to break out into a full-scale debate on this issue.
Let's move on. Any other senator wish to be heard on this bill? If not, the amendment, I'm sorry, yes. Oh.
Mr. Speaker, I'm sorry. No, just a point of clarification. I believe the parentheses B, Bravo, was changed or was recognized that it was a different section, subsection. Is it R? Because I don't want us to act on this particular amendment, and should it pass, then certainly it may change the original discussion and the correction. So I just wanted to cite that, Mr. Speaker.
It was my understanding yesterday that it was R. On the amendment, any objection? On the main motion, any senator wish to be heard on the main motion? On the main Vice Speaker?
Thank you, Mr. Speaker. I support the bill, and I'm just trying also to, I guess, make sense of how this would be different than what we do in other cases or with people from other jurisdictions. And if the author would yield, I would just ask him that, I guess, if that hasn't, even despite the discussion earlier, if the author would yield.
Senator?
Yes. I would just like to know, how then does this, because right now we have a provision where people can do this, right? But so what is the difference with this act and the current discretion of the department? This is just to make it mandatory?
Yes, it establishes it formally in statute that that there is a process by which they may exchange their license. Let me give you an example. So this came this is a personal experience maybe 4 or 5 years ago when a woman known to me, 60 plus years of age, relocated to Guam. Her son, who's a physician, relocated to Guam, and she moved back to help her family and was asked to provide an affidavit that she's been driving in the CNMI for at least 5 years. And that's why I was referencing, and I was wrong in referencing the gentleman's name, but the senator from Barragata, I was reminded by the minority leader of the standing rules, so I appreciate that reminder. Please forgive me. So the senator from Barragata was correct in citing section 31A03, that one of the methods by which you may establish that you held a driver's license in good standing was to get this piece in writing. And we're talking about an elderly woman who doesn't have WhatsApp or a fax machine, or I'm not even sure if she's active in email. Now she does. But 5 years ago, it was a point of frustration. So you're asking someone to make a phone call, pay for mailing charges to have this affidavit sent to her. That was the elected means, or one of the chosen methods by which she would have to furnish something so she can exchange her license from the CNMI, for which she's probably been driving as long as I've been an adult and had my license. And so the point is, how, for me, it was a pretty straightforward common sense piece. Why would we impose such restrictions or barriers to entry to people who drive on the same types of roads? Now, maybe they don't have a 6-lane highway yet, but they certainly, I was having a discussion, for the record, they certainly do have 4-way stops and traffic light signals and heavy equipment and all that other good stuff. But I just didn't see it. It didn't make sense to me, Madam Vice Speaker. And so, yes, previous speakers are absolutely correct that the director has a lot of discretionary authority in choosing when or when not to apply certain provisions within the statute governing driver's licenses. This would make it, I guess, permanent and not as discretionary. I hope that satisfies your answer.
Vice Speaker.
Yes, thank you. I guess I was just concerned that there were other things that the Department of Revenue and Tax, and I was hoping that their testimony was going to cover these things because they were not at the public hearing, as indicated earlier. Yes, the other things that they look at, and would they still be able to look at those things in this case? But I've read their testimony. They're in full support. They don't seem to be asking for any other authority to review these licenses as they do for all of our licenses and our applications and driving records and things like that. Thank you, Mr. Speaker.
Thank you. On the main motion, any other senator wish to be heard? Any other senator wish to be heard? If not, Senator Castro, you're welcome to close.
I just want to thank you, Mr. Speaker, for the opportunity to offer brief remarks, or what turned into somewhat extended remarks, on Bill 123. I want to thank my co-sponsors. I want to thank the Director of the Department of Revenue and Taxation, the Deputy Director, the Governor and his team, Representative Ivan Blanco, Governor Ralph Torres for their stated support of the measure. And I did, in my own lack of knowledge and firm grip of protocol, overstepped when I called out my colleagues, and I humbly apologize, and I thank you for your support for those who stated it, and I hope I still have it. Thank you, Mr. Speaker.
Thank you. On the motion to send the bill to the voting file, any objection? Senator San Augustine, you're recognized on Bill 150.
Thank you, Mr. Speaker. Mr. Speaker, I move to place Bill 150-34 COR on the third reading file.
Any objection? You're recognized.
Mr. Speaker, my colleagues, the bill you have in front of you was drafted and presented to me by the Department of Revenue and Taxation. It is a bill that the licensed low-income housing and program have been faced with a dilemma when it deals with taxes, real property tax. I know that some of you are probably thinking, well, why aren't they paying the taxes? Well, when they had the reevaluation pass on real property tax, that's when it triggered them to go through the process of revenue and taxation to apply for some tax credit, because they're actually governed where under the HUD program, they can't charge any more than what is allowed by their program. So whatever they have, they pay out of pocket to maintain that program. And what they're asking for is a fair taxable formula as done in other states. I have provided copies, some information for my colleagues. I hope that you have read it and you have met the requirements. Because during the public hearing, a lot of the questions were asked. One was asked by Senator Terlai about the reimbursement. There won't be any reimbursement. As a matter of fact, the low-income housing program has been in arbitration with the Board of Equalization. And if this law is passed, enacted, then they'll pay whatever they're required to pay for 2014 and 15 and up to date. If it's not passed, then they know they have to go back in, and the Board of Equalization will tell them, this is the fees you have to pay, and they'll proceed from there.
You're recognized, Senator Nelson.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to stand in support of this bill. You know, this is we give a lot of QCs to big corporations, And this bill addresses the low-income market, low-income homeowners, and I think this is also particular in the most recent formula that has been figured out on how to own a home at an affordable price. And we have a program, the Sweat Equity Program, that allows this to happen. And essentially what happens is that these families come and they put in the labor that it requires to build a home. And you know, of course, they don't have the kind of money to purchase a home or get a loan at a bank. Perhaps their credit is not as established, or perhaps the income does not meet the requirements to build a home. And as we full well know, because of the H-2B crisis, we are dealing with our homes being built in the past for $90 per square feet to the upwards of almost $200+ per square feet to build a home. And so this bill really focuses on the people, the working class people. And I think that it is an appropriate bill because we need to also start working for their best interest. And so I thank the sponsor and the co-sponsor for this bill. It's a little bit, it's a little bit complex, but to understand the gist of it, this helps the working class family. This helps those that are low income, are in low income housing, and that also look to build their own homes as part of like a sweat equity program or an agreement with HUD and USDA. So I stand in support of this bill. Thank you.
Thank you, Senator Nelson. Speaker Cruz, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I'm not rising in support or in opposition to the bill. I'm just concerned that if we're going to be giving a special tax credit to the LIHTC group, the fiscal note that was provided to us states that there's no revenue. It's not going to affect the revenue. And I keep trying to figure out how that's possible. If you're going to give a tax rate to those huge, under the LIHTC, we built several hundred units, and I don't know what the tax rate that they're fighting with at Board of Equalization, but to send us a fiscal note that says there's not going to be any fiscal impact or zero, I just want to put that on the record that I have grave questions about that, that it's impossible that you can, that you can pass a piece of legislation that isn't going to affect the revenue. There is a break for those of us over 60, and that costs money. That costs the government money. I didn't apply for it when I reached the age of 55. My bank was the one that finally did it. When I got a check back, I was wondering why I got a refund, and they told me, we noted that you were a senior citizen and you should have applied for the senior discount in the tax, and so your trust fund, as it relates to your real estate tax, is not as great as you set aside, so you receive the balance back. And so I'm just trying to figure out how much this is going to cost us. And I know that as the chairman of appropriations, I'm always looking out for every cent that we possibly are going to lose. And I can't believe that this is zero. I would have posed the question to the sponsor, but the answer I would have gotten would have been the fiscal note, and the fiscal note says zero. So I just want to put that on the record, that the fiscal note says zero, no impact.
Sidus Mahasi, I have Senator Siniclis and then Vice Speaker Cherlahi. Senator Siniclis, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I'd like to take a moment to just very clearly spell out exactly what this bill is doing. What this bill does is it seeks to create a special property tax rate on Guam for those houses that are part of the low-income housing tax credit program. This low-income housing tax credit program is a federal program. It's a federal government program and is currently the country's most extensive and affordable housing program. The program was added to Section 42 of the Internal Revenue Code in 1986 in order to provide private owners with an incentive to create and maintain affordable housing. Now, it was mentioned earlier in some prior statements that this has something to do with allowing people to have a home at a lower tax cost. But when you actually read through the bill, every single section here has to do with rents. Even the title, and real property with deed restrictions involving rental caps. On page 1, line 8, rental caps. Line 10, used for residential rental purposes. Page 2, line 9, gross income, implying that it's a rental property. Lines 11 and 12, residential rental purposes. Every single section here refers to rents. Basically, this bill would create a new property tax formula based on the rents received from by a landlord on a house that's part of this low-income housing tax credit program. That doesn't necessarily make the rents go any lower. It just means that we're basically creating we're further incentivizing this program where all of these houses that already took advantage of it on the federal tax credit side are now going to be able to get a discount on their property taxes based on this formula. It's problematic for me, Madam Speaker, on several levels. First of all, this tax credit is already an incentive for houses to be constructed under this program and made affordable. Secondly, this new property tax rate would not necessarily translate into even lower rents for the tenants. Third, those property taxes go to our Territorial Educational Facilities Fund, which goes now all over the place, but generally supposed to be going towards educational purposes, particularly in our public schools. It goes to our mayors. And so lowering that tax rate would result in lowering those revenues. We've already had a historic problem with the Territorial Educational Facilities Fund bringing in the revenues that it needs. Not only does this bill have the potential to negatively impact that, because the fiscal note says it has a zero impact, it's obviously clear that nobody quite knows what that impact will be. I'm all for trying to create incentives, especially to facilitate the needs of the community, but I'm just not quite sure that this is actually going to achieve that. We actually have quite a number of properties that take advantage of this program, as was mentioned by the retiring speaker. I don't think that there is necessarily a challenge trying to get developers to take advantage of it. We have hundreds of homes built under this program. So why are we going to forego the property tax revenue by creating this whole new property tax formula that doesn't necessarily result in lower rents and really only reduces the property tax liability of the investor? I'm not entirely sold on that. It's almost like saying, if you want to go and build a store, not only are we going to give you a tax break on the federal income tax side if you accept public assistance, but also for every dollar that you sell in public assistance, we're going to reduce your property taxes as well. It doesn't necessarily mean that people in public assistance are getting lower prices. It does mean that the establishment is being able to write off more of that income. So I caution the body on the impact that this may have that is currently unknown. It will be immediately applicable to every single rental property that's already out there, generating rents and paying these property taxes. I mean, I have not heard of any crisis out there where our already extremely low property tax rate, it's the lowest in the country by multiples. I have not heard anywhere that our already extremely low property tax rate is creating an undue burden on the low-income housing tax credit program and is being a barrier to entry for investors to try and build these low-income homes. Now, if we had somehow written in here that on a dollar-for-dollar basis, the reduction in property taxes shall further reduce the rents, I can get behind that, by all means. But that's not written in here. It basically means less tax cost to the investor, not necessarily lower rents to the tenant. So at this juncture, I would need to rise in opposition to this measure. We already have a very constrained budget environment as it is as well, as was mentioned by the retiring speaker. Let's be more cautious with how we advance these kinds of legislation until we are very, very clear. They do provide a formula here. If you look at page 2, and it reads, I'm starting on line 22, by way of example, if a property generates net operating income of $100,000, then that property will have a taxable value of $100,000 divided by 0.0941 equals to $1,062,699 times 70% equals to $743,899. Property taxes for this example property would be $743,889 times the applicable millage rate. I mean, quite complicated. I prefer, and by the way, the government, if we do further research on this, the government can find out all of the properties in this program, and we can get some hard numbers as to what the impact would be. Perhaps that might be a better course. I'm, like I said, not comfortable voting in favor of the bill. I'm not quite sure what its trajectory may be in the voting file. Perhaps we may want to even consider sending it back to committee until we get a firm handle on what those impacts would be. I would, I guess, like to leave that out there. If anyone would like to make the motion to do so, I would further support such motion. Thank you, Madam Speaker.
Thank you, Senator San Nicolas. Vice Speaker Chalahi, you're recognized.
Thank you, Madam Speaker. At the public hearing, I heard the testimony, and particularly there was a lot of testimony from one of the developers, from the tenants of one of these real properties, and the managers. But what was not at the public hearing and not in front of us today is testimony from the Department of Revenue Tax or the commissioners. I was hoping that they were also going to provide some testimony. But what I thought was reasonable in this proposal is that this particular, well, they were asking that, this is in the effective date, really, they're asking that part of their program is to cap the amount that they can charge to those people that are renting property from them. So they cap the rental rates. But at the same time, real property rates had risen because of the assessment. And so they are asking in this effective date language that their real property rates be capped at prior to the assessment, when they, were established, when their rental rates were established, so that I guess they wouldn't bear an increased cost over what they had anticipated. My concern with the bill was that, there was one kind of technical concern brought up, but I don't know the answers to it. It was about on page 2 of the bill, they talk about the formula and they use this operating expenses, and it sounds to me like this is the term that I was really hoping that we were going to get some input from Department of Revenue and Tax, because this is the term to me that maybe could have used an additional just clarification. But so they put this, they use operating income or operating expenses as part of the formula. So that was one concern. But my biggest concern is what's also been shared by the previous speakers, and that is the impact to Gov Guam. It was, I was also hoping that the Department of Revenue and Tax is the person that could tell us this immediately. But I noted on the fiscal notes, if you read the notes, you know, they have their standard form, but on the back of it, they have extensive comments. And in the comments, the BBMR has predicted that they use a certain formula to calculate the impact of this, and they said, if I'm going to the two bottom paragraphs of the BBMR's statement, and it says, after they did a sample formula, using the example property, we can see that the proposed calculation reduces the property taxes to a little over half, 54.8% of what it would currently be assessed. That's because the bill not only changes the appraisal value base, but it also changes the percent that taxes are assessed. And then they say, they believe that 2,500 Section 8 vouchers are being distributed, and that means that at the very least 2,500 landlords will benefit from this legislation. I did not hear that at the hearing. At the hearing, it was indicated, I thought, that there were currently 14 properties listed in the low-income housing database. So I understood that 14 properties would be affected by this. 2 of those were Cortec and Ironwood. The final paragraph in the BBMR statement says, finally, in order to project potential fiscal impact without any actual net income available, we will take the above reduction of 54.8%, assume that 10% of TEFF funds comes from the properties covered by this bill, and apply it to the estimated TEFF revenue of $29.2 million requested in the proposed substitute bill 22. That's the budget bill for FY 2018 budget. Using this data, we get a potential reduction of 1,603,470 in TEFF revenue. This estimate does not include the impact of the provision in this bill that mandates taxes overpaid for the year 2014 and each calendar year thereafter be refunded. So I was concerned about the potential impact of this bill. I don't know if the Committee on Appropriations would be concerned if this is the actual number that we're looking at, but I do believe that it's something that, according to the bill and according to those testifying, they're asking us to weigh the potential impact, which, you know, perhaps 1,600,000, weigh that versus the benefits of this program. And I have to concede that I think that the program is very good. It's a very good program. The tenants, of course, they were very happy about it. It seems that by keeping the taxes at the current or the rate prior to that the triennial assessment, that they would be able to put more money back into the property is what I understood, and that the tenants like this because this is where they're getting programs that they believe are creating a community. It looks like a place where people live, and they actually have community programs. They have after-school programs, education. They had, you know, sports or martial arts programs, things like that, that according to this one property, they were putting these benefits back into the community, and they would be able to continue to do that if we could keep their real property rates at a certain rate. So I very much, I mean, I like that, of course, but it's one of those things where we, you know, as a legislature, we can hand out benefits, but or we can not allow people, or we exempt people is really what we're doing. We're not handing out a benefit. We're exempting them from certain taxes, or exempting them, from this, in this case, real property taxes, but it's just preventing us as a legislature from deciding where that money will be spent, or in putting in our own educational programs or things like that. But I do commend this property, this program, and so I'm going to continue to think about this. But I wish that we could get some real testimony from the Department of Revenue Tax if that's available. Thank you, Madam Speaker.
Thank you, Vice Speaker Chalahi. Senator, again, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I guess much of the discussion, the items that I wanted to discuss have already been shared. And one is the financial implication. And the previous speaker mentioned about the effective timeline. And it's kind of interesting that, in fact, it would not, based on what the good speaker mentioned a little earlier, that it will not have any financial implications. But when you take a look at the effective date that's contained in this provision, which was just highlighted, is that this shall be effective with property taxes levied in calendar year 2014 for collection in calendar year 2015 and each calendar year thereafter. And it brings into question that if in fact it had zero implications, then certainly it did not, if it did not impact the government coffers, in spite of it having a retroactive application, I think that that's certainly a concern that I also share with some of the other speakers. Madam Speaker, you take a look at the program, and certainly I expect that a lot of the comments that were shared was really not reflective of the program itself, because the program has provided low-cost housing and rental units specifically to our people who qualified. And I certainly understand that it's not the idea of providing tax reprieve to any of these business owners, because they're providing a tremendous service to our community. I want to read one particular statement that was highlighted by a representative from Ironwood, which is one of the beneficiaries of the low-income housing tax credit. And this individual highlights in his letter, just a paragraph, communities were financed with low-income housing tax credits. This is a federal program that requires that for a period of 15 years, the units can only be rented to tenants earning less than 60% of the area median income. Further, the rents are set by HUD, Housing and Urban Development, federal entity, annually, and must be limited to what a person making less than 60% of the median income can afford to pay, which equates to rents of approximately half of market rents. The low-income housing tax credits program has been extremely successful in Guam, allowing nearly 1,000 new units to be built with federal subsidies that help offset the high cost of construction on island. I believe that that particular statement, Mr. Speaker, certainly highlights the tremendous benefit that this program has been providing. But one thing that stood out in my mind when I was reading this paragraph is that the statement, this is a federal program that requires that for a period of at least 15 years, the units can only be rented to tenants earning less than 60% of the area median income, and at that particular threshold. So what would happen after the 15 years, Mr. Speaker, is the owner of these housing units or rental units, are they given an opportunity to continue to take advantage of the formula and the reduced land tax payments that is purported under this particular proposal infinitum, indefinitely into the future, or would it be suspended and would it conclude after that particular time frame has expired? And those are questions that I certainly want to share with the members of this body, because first and foremost, It's effective as of calendar year 2015. Secondly, most of these low-income housing programs cover a time frame in terms of the restriction for individuals earning 60% of the median income to be able to be housed in these facilities for a time frame of 15 years. So what would necessarily transpire after that? Would they now no longer have to avail, or would the business owners no longer be able to avail themselves of the low taxes, real estate tax rate that is proposed in this particular provision, or do they continue to benefit from it indefinitely into the future? Those are certainly questions that should be answered as we deliberate on this particular measure. Thank you very much, Mr. Speaker.
Thank you very much, Senator. Senators, any other senator wish to be heard on the main motion? On the main, Senator Espaldon.
Thank you, Mr. Speaker. Some really insightful comments and perspectives that were presented by our colleagues here today, and there are some questions that do need to be answered. May I just have a few seconds to confer with the sponsor of this and to see where he might want to go with this bill? May we have a quick recess, Mr. Speaker?
Short recess.
Thank you. Thank you for that recess, Mr. Speaker. Mr. Speaker, again, I value the input and the questions and the concerns and the perspectives that were provided by the previous speakers. The way I read it, this bill provides that the assessed valuation of property used for such residential rental purposes, subject to the low income housing tax credit, shall be determined by using the actual net operating income of the properties instead of the construction or replacement costs. If Guam passes this tax relief for affordable housing, it will join most other states in the Union in providing property tax relief for affordable housing. All of Guam's nearest neighbors, including Hawaii, California, Washington, offer tax breaks for affordable housing projects, and in some states, such as Massachusetts, offers a full property tax exemption for affordable housing. This particular bill does not provide a full exemption from taxes, but merely levels the playing field for affordable housing by connecting the tax valuation to the actual income potential so that property taxes remain affordable over time for these kind of low-income housing type of projects. But Guam still collects property taxes from these properties. Now, if the current system of replacement cost was imposed on affordable housing, the projects would initially struggle to break even and soon would risk default because there is no revenue source available to meet this much higher tax burden. And while cost approaches, comparable sales and income capitalization are all acceptable property valuation techniques for most commercial properties, only the income approach provides for a fair way to value the low-income housing tax credit properties, given that their incomes are restricted or capped by HUD and general illiquidity. Now, it is true that BBMR's fiscal notes basically estimates a potential reduction of $1.6 million into the TEFF revenue, and as many as was mentioned previously, as many as 2,500 units may be affected if this bill is passed. The potential of the $1.6 million in TEFF revenues going down by providing limited tax relief needs to be weighed against the ability to provide affordable housing inventory. And I think that really is the situation we're in. While yes, the valuation will allow developers to develop more affordable housing, and we all know that more is needed for those in the low income bracket, we must weigh it, we need to weigh it against the potential loss of revenue into the Territorial Education Fund, Facilities Fund. And that's really the problem, at least for me, in deciding on where I stand on this. But I wanted to at least present that perspective, that we have a potential to increase the number of affordable housing rentals to the low-income families on this island versus the loss of revenue to the Territorial Education Fund. And again, I am not fully decided on where I would fall on this side of the vote, on what side of the vote I would fall on, but I at least wanted to present that view, my view on this. Thank you, Mr. Speaker.
Thank you very much for that perspective, Senator. Any other senator wish to be heard? Senator Rodriguez.
Hafaday, thank you, Mr. Speaker. Mr. Speaker, I rise, of course, in favor of this piece of legislation, and I do appreciate some of the concerns that were raised in terms of the potential impact this may have to our revenues. However, it's also important that we act on measures like this, Mr. Speaker, to promote and incentivize further the affordable housing market on Guam. And this tax rate, Mr. Speaker, wouldn't apply across the board. It would only apply to those properties that have a deed restriction, such as what it says here in terms of a cap on rental property. So it's not for other perhaps Section 8 rental properties. Also, as the previous speaker has just mentioned, other states have enacted statutes like this to allow for this special type of tax rate, because without this authorization and statute, the Board of Equalization or Revenue Tax wouldn't be able to come up with this kind of formula. So I think it's a good step in increasing and promoting the affordable housing we have for our people. So I ask our colleagues to please support this measure. Thank you.
Thank you, Senator. Any other senator wish to be heard on the main motion? On the main motion, Senator Nicholas, did I see your hand go up?
I did speak already, Mr. Speaker, if I may be so obliged.
That's fine.
Thank you, Mr. Speaker. In my previous comments, I forgot to touch on the other concern that I had with regards to the end of the legislation, the effective date. I know that statements have been made that the purpose of this legislation is to further incentivize the development of low-income housing programs. But this effective date backdates the implementation. So it will take us back to 2014, and the formula would need to be applied to all of the property taxes that have been being paid since 2014, and then they would need to get that back in terms of a credit, a rebate. Now, if they're already paying the property tax since back then, you know, that the houses were already built, the incentive was not necessary to get those houses built. That credit would then be, they could apply that credit to this already lower property tax, thereby driving down even more the property taxes that they bring in. And so the initial presumptions of 1.6 million or the other numbers that were mentioned could actually be exacerbated, because that would be the amount, if the credits were not applied to the remaining property tax, that this new formula would assess. If the credit is applied to that remaining property tax, it could be much larger. If it's 1.6 million per year, multiply that from 2014, 15, 16, 17, and all of a sudden you're looking at 1.6 times 4. I don't know if we can afford a $6.4 million drawdown in the TEFF. So I'm concerned about the effective date going back to 2014. I think that, I mean, if we're going to even entertain this, which I still have a challenge with, because, Mr. Speaker, you know, all those incentives that are in all those other states, the property taxes in all those other states are markedly higher than ours already, which probably would justify the incentive. But even with their incentives, with the exception of Massachusetts that was mentioned that wipes it out entirely, even with those incentives, our property tax rate is probably still lower without passing this legislation. On top of that, in the states, you know, you have property tax rates that are higher, you have state taxes on top of the federal income tax. We don't have that here. You participate in this program here on Guam, you get to enjoy the full benefit of this program without the additional tax burdens of other jurisdictions. So I can understand incentivizing it in other places to perhaps sweeten the pot, but here the pot is incredibly sweet. And then now we're going to backdate it to 2014? I don't know. So because that impact is something that I think might be just a pill that's too big to swallow, I'd like to make a motion to amend the bill to basically strike the Section 2. And in so doing, the effective date of the act will be for property taxes levied in the current calendar year. So if I can make a motion to strike Section 2, lines 4 to 10, which basically backdates the tax credit.
On this Nicholas amendment, any senator wish to be heard? Senator Snogestein.
Mr. Speaker, just to inform my colleagues that as we worry about any reimbursement, there hasn't been any payment made. So when we talk about the loss of revenue, there hasn't been any collected from them yet, because they're in arbitration with the Board of Equalization. Until that's settled, if the act is passed, whatever they need to pay, they're ready to pay. If the act's not passed, then they will have to pay whatever they need to pay, because then it will end the Board of Equalization's dilemma. So if we're worried about the year was established only because that's when the reevaluation of the property tax came in place. That's why it was dated then.
Thank you. On the amendment, is there an objection to the amendment? There's an objection to the amendment. All those in favor of the amendment, please indicate by raising your hand. Motion passes.
Mr. Speaker, in light of that, I think it becomes necessary for us to at least understand what the impact is. I'd like to indulge legal counsel once again, at least to have them on a technical basis.
There's been a question as to whether or not I count a date. let's vote it again. All those in favor, please indicate by raising your hand. 1, 2, 3, 4, 5, 6, 7, 8. No, there was a question as to whether or not I correctly counted, and I'm just reaffirming that there were 8. I don't know if the clerk caught it. Motion passes.
Okay, thank you, Mr. Speaker. My only other question now is, while we remove the backdating provision, I am still concerned that this formula is pretty complex. I even have a difficult time trying to wrap my head around how this may or may not materialize. And so I would probably like to request a reporting requirement from the Department of Revenue and Taxation to report the total amount of property taxes that were collected as a result of the implementation of this program, as compared to what they would have been collected if this measure was not in force. So if I could just indulge legal counsel to create the technical amendment to require that reporting requirement.
On the second St. Nicholas Amendment for a reporting requirement to be written by legal counsel. Any senator wish to be heard on the amendment for a reporting requirement? Any senator wish to be heard? Senator Espaldon?
No real comment. I guess there's just a question exactly what will be reported again?
Just the difference in the taxes paid under this regimen and what would have been collected had the original, the current tax rate been implemented. That would have been the loss, whatever the loss.
Oh, okay.
Difference is.
Okay. I mean, it seemed to me, and I have no problem with that. It would just seem to me that really should have been provided before we even go forward with this bill. I mean, but
I would have thought.
But yeah. Thank you.
Any objection? Any objection to the reporting requirement? Senator Nicholas.
Thank you, Mr. Speaker. And in just some sidebar conversations with some of my colleagues, we've made some amendments. I still think that there's just some uncertainty with respect to the legislation. I mentioned earlier when I spoke, and I appreciate the indulgence to speak again, as to whether or not sending it back to committee may be something that we may want to consider. I would like to, at this time, with amendments intact, make the motion to send the bill back to committee pending the clarification, really, on the impact and what that would entail with respect to the coffers. Mr. Speaker.
Any objection? It's an objection. All those in favor of returning the bill to the committee with the amendments intact? All those in favor, please indicate by raising your hand. This motion fails. Okay. Any other? Do you wish to close, Senator Snogestein? On the motion to send the bill down, there being let's meet tomorrow at, oh, I'm sorry. Senator Regine, you're recognized.
Suzasmasi, Mr. Speaker. Notwithstanding the House rules, I move that we revert back to motions.
Any objection? Please.
Thank you, Mr. Speaker. I move to reconsider the vote on Resolution 228 as substituted on the floor on this legislative day. I voted in favor of this resolution out of committee, and I would greatly appreciate my colleagues providing me the opportunity for the voting record to reflect my support of this resolution. It's my expectation that the voting record will not change for my colleagues, but I respectfully request support for this motion so the voting record can accurately reflect my aye vote. Suzasmasi.
Is there any objection to the motion? Yeah.
Mr. Speaker, may I ask, has that resolution been transmitted? It was supposed to be transmitted. It has? It has not?
No, I believe it. I've signed it. I don't know. Oh. Huh? I guess it has not been transmitted. I thought I signed but I guess it hasn't.
Mr. Speaker, I move for the call of the House.
Mr. Speaker, may I request for a recess?
We'll recess.
Thank you.
We're in motions. Senator Snogestein.
Mr. Speaker, notwithstanding the House rules from the Committee on Education, Finance, and Taxation, I move to place appointments of Celestian C. Babauta, the position of General Public Member, Guam Academy Charter Schools. And I have three of them. And Lisa J. Provido for position of member for the University of Guam Board of Regents. And Marissa Q. Mears, position for member of the Guam Public Library.
Point of order, Mr. Speaker.
What other thing?
And with all due respect, there's a motion before us that needs to be addressed, and we have not.
I understand. I just wanted to get those on so that we can take care of it, and we'll deal with this other one.
Thank you, Mr. Speaker.
And to be placed onto the session agenda.
The three appointments, any objection to the three appointments being added to the agenda? On the other request, is any senator wish to be heard? On the motion to send it to voting file, the three appointments, he just asked to be recognized, and I guess I thought that was the motion, but anyway, the three appointments are in the voting file. On this other amendment, we'll just take a short recess. Before the body, there's a motion to reconsider. Is there an objection? Senator Nelson,
Thank you, Mr. Speaker. On the motion, I'd like to address something.
please.
Thank you. Mr. Speaker, we wanted to do this with a sense of urgency. And what troubles me is that, from what I understand, that this resolution has still not been transmitted. And that's disappointing. Because the sole purpose of splitting the Committee on Rules was so that a young senator can understand the responsibility of Committee on Rules to prepare us to develop this legislature if the people allow us to. And the fact that it has not been transmitted and now this motion is coming into place is very disconcerting. I don't know what the reason behind the hold of the transmission was. I'm hoping that there's a good answer to it. Because us as a body has worked really hard and were present to vote, because every single one that was present that day on Tuesday knew the importance of this resolution. Even the people that opposed the resolution remained here. So, Mr. Speaker, I understand that for whatever reason, life happened that day for an individual, and that individual was not given the opportunity to vote. And I want to make it known that I requested her absence to be excused so that her vote would not be a no vote. Not because I didn't want that voice heard, but so that it wouldn't go on the record to be a no vote. And so I'm very disappointed that now we come here as a body for one individual, but I think it's due process, and so be it. I don't object it. If this individual is so willing to do it, so eager, I do not object it, Mr. Speaker, but I am confident that everyone that voted yes, that their vote will remain yes and unwavered. Thank you, Mr. Speaker.
Thank you. There being no objection on the motion to reconsider, with the reconsideration, was there a request to re-vote? Is that why you're reconsidering? Is there an objection to restaging the vote? Hearing none. Roll call. Senator Torres.
Thank you, Mr. Speaker. This was a rather unusual resolution in that we took one whole day and a half to deliberate as a body because there was a sense of urgency. And at the time, too, there was a set of circumstances that were presented to us that compelled us to take a vote. At the time, I did not think that was a compelling reason, that there was no demonstration based on letters that were provided the following day that, in fact, the area was going to be disturbed and all of that. And so I took a position at the time, based on the set of circumstances, that there really was no compelling need to call for a pause because destruction of historic places was not imminent based on the letters that we had. But since the vote, Mr. Speaker, there have been a couple of things that have come up that caused me to now reconsider my vote. and that is the call by the State Historic Preservation Officer, and there was also an indication by the governor that he takes a certain position. And with those two pieces in place, Mr. Speaker, I think that it does warrant a pause in my opinion. I have always held on to the notion that this military buildup is a decades-long question, and in fact, many of the concerns had been brought up, but I thought sufficiently brought up. But in light of what the State Historic Preservation Officer, whose task it is to ensure that those areas are in fact well covered, I just want to indicate that, you know, we do have, in all situations where decisions have to be made, we weigh the facts that are before us at hand. And the military buildup is imminent, but I think that we do owe it to those officials who are in charge who we give the charge to ensure that certain things are covered, the due process. And in light of the objection that was presented, I think that that's a set of circumstances that warrants my reconsideration. And I just want to state that for the body today. Thank you, Mr. Speaker.
Thank you very much, Senator. Read the title and
Resolution number 228-34 COR as substituted on the floor, introduced by Chelina Cruz Nelson, relative to calling for a pause on construction and pre-construction activities related to the U.S. Department of Navy's proposed live fire training range complex at Northwest Field until final determinations are made by the U.S. Department of Defense as to the series of associated live fire training ranges in Guam and the CNMI, and all related activity litigation is resolved in order to ensure the protection of the environmental and cultural resources of the northern coastline of Guam.
roll call.
Senator Atta. Senator Atta, nay. Senator Uggan. Senator Uggan, aye. Senator Castro. Senator Castro, aye. Speaker Cruz.
Aye.
Speaker Cruz, aye. Senator Espadon. Senator Espadon, aye. Senator Esteves. Senator Esteves, aye. Senator Lee. Senator Lee, aye. Senator Morrison. Senator Morrison, aye. Senator Muña. Senator Muña, aye. Senator Nelson. Senator Nelson, aye. Senator Rodriguez. Senator Rodriguez, aye. Senator San Augustine. Senator San Augustine, aye. Senator San Nicolas. Senator San Nicolas, nay. Vice Speaker Terlahi. Vice Speaker Terlahi, aye. Senator Torres. Senator Torres, aye.
Resolution 228-34 received 13 ayes and 2 nays. Resolution 228-34 is duly passed by the 34th Guam Legislature. We have a whole set of bills to engross. I don't believe we have anything left on the motions on the second reading. So can we be ready by 3? So 4 o'clock for vote tomorrow. Okay. So we'll recess till 4 for voting tomorrow afternoon.